court documents, former colleagues who were present when it happened, and 5 days of on-the-ground reporting by a journalist who went to El Bouquet and spoke to the people there. That is the sourcing behind what you are about to hear. Not a theory assembled from screenshots, not a Reddit thread. Court documents, former colleagues, documented on-the-ground reporting. Brian Hooker was fired from AT&T for jury-rigging the GPS tracker on his company van. The purpose was to prevent that tracker from accurately reporting his location to his employer. Multiple former colleagues witnessed it. The firing generated court documents. Ashley Banfield confirmed all of it after spending 5 days reporting in El Bouquet, speaking to sources on the ground, and accessing records. The conduct, the court documents, the former colleagues who were there. That is where this video starts, not with atmosphere, not with scene setting, with a confirmed documented fact that now sits at the center of something much larger than an employment dispute at a telecom company, a disappearance investigation, a search warrant citing bodily harm, electronic devices seized from a sailboat, and an active review of digital evidence by people who work with location data professionally. Brian Hooker has not been charged with any crime in connection with Lynette's disappearance. He is presumed innocent. That presumption governs every claim in this video, and it will be said again before we're done. Confirmed facts are labeled as confirmed facts. Analytical inference is labeled as analytical inference. Those distinctions will be held throughout. But the AT&T record is confirmed. And in the context of a digital evidence investigation centered on location data, that record is not background noise. It is the frame through which every other piece of this investigation has to be read. Let me be direct about what this means before we get into the mechanics of the investigation. An investigation built around digital location data is trying to answer one question. Does the electronic record of a specific night confirm what a specific person said about that night, or does it contradict it? Every piece of evidence exists in relationship to that question. The Starlink handshake data either places the vessel where the person said it was, or it doesn't. The AIS signal either matches the stated position, or it doesn't. The device logs either reflect what the person described, or they reflect something else. For most people in most investigations, the digital trail exists because the person was there and the systems were running. They never thought about the trail. They have no professional understanding of the infrastructure generating those records, where the data lives, or what the monitoring end of each system can and cannot see. That is not the situation here. Brian Hooker's professional background is the background of someone trained by one of the largest telecommunications companies in the world to understand how these systems operate at a technical level. And the court-documented record of his employment shows that he didn't just understand the technology, he applied that understanding deliberately to defeat a location tracking system. That changes what investigators are looking for. It changes how they read gaps and anomalies. And it changes the entire context in which the digital evidence review will be understood. Before the warrant. Before the digital evidence. Before any of what we're going to get into. Lynette Hooker was a person, and she deserves to be remembered as one. She and Brian had built towards something that most people spend their lives imagining and never actually attempt. They acquired a sailboat, the Soulmate, and were living aboard, cruising through the Bahamas. You don't end up on a live-aboard vessel working through the Exumas and the Abacos by accident or on impulse. You get there through years of deliberate planning, savings, acquired skills, and a shared commitment between two people to build a life that looks different from the one most people settle for. You have to want it enough to actually do it. Lynette wanted it. She was not a passenger in someone else's vision. She was a partner in a shared life that the two of them chose and built together. She loved the water. She was out there, in beautiful and remote places, in conditions that require competence and courage and trust. That belonged to her. She disappeared on April 4th, 2025, in the waters near Elbow Cay in the Abaco Islands of the Bahamas. She was with Brian aboard the Soulmate. She has not been found. Her family has been waiting since April 4th for answers. Everything in this video is offered in that spirit, to document the confirmed record of an investigation they have every right to understand, clearly, accurately, with every source identified. Case context: April 4th and what followed. Brian Hooker's account of April 4th, documented through reporting across multiple outlets, is this. Lynette fell from the dinghy they were using near the Soulmate in waters near Elbow Cay. She went into the water. Despite efforts to locate her, she was not recovered. Brian reported her missing. That account produced a search. Fire and rescue volunteers responded. The maritime community around Elbow Cay engaged in the way small maritime communities do when someone is lost in their waters. Brian was present through all of it, talking to people involved in the search, speaking with journalists covering the story, interacting with volunteers and friends. Something in what he said, or in what investigators were separately assembling, led to a search warrant. CBS News confirmed the specific legal basis cited in that warrant: bodily harm. Not just that a warrant was executed, the basis. Those two words are a legal designation reviewed and approved by a judge who found that investigators presented sufficient probable cause to authorize a search of the Soulmate on those grounds. A judge signed that document after reviewing what law enforcement had assembled. The warrant was served. The Soulmate was searched. Electronic devices were seized. Brian Hooker has not been charged. A warrant is the beginning of an evidentiary process, not the end of one. It establishes that investigators had sufficient grounds to look. Not that they found anything conclusive. Not that the case is resolved. Not that guilt has been established. The threshold for a warrant is probable cause, which is a lower bar than what a prosecution requires, and lower still than what a conviction demands. But bodily harm as the cited basis, confirmed through CBS News and sourced from the warrant document itself, is a significant and specific legal designation. And the seizure of electronic devices under that warrant placed the digital evidence review in motion. Before we get into the 4 specific data categories investigators are reviewing, and into the professional background that makes how those categories are read so important. If you are following this case and want every confirmed update as it comes in, please subscribe and hit the notification bell. Every verified development covered here, sourced and attributed every time, and drop a comment based on the 4 confirmed data types in this investigation. Specifically Starlink handshake logs, Apple Watch connection records, AIS positioning data, and Google search history. Which of those do you think is most likely to produce the most significant evidentiary finding, and why? I want to know where the people following this case are landing. I will read this comment section. Spores, the self-portrait, what Brian Hooker told the people around him. There is a specific detail in this case that has not gotten nearly enough attention, and I want to give it the attention it deserves. Multiple sources, confirmed through Banfield's reporting after 5 days in Elbow Cay, describe Brian Hooker presenting himself to the people around him after April 4th as someone who was not comfortable with technology, someone who struggled with basic digital tools, someone who told people, and this specific detail is confirmed across multiple separate accounts, that he did not really know how to use WhatsApp. For context, WhatsApp is a consumer messaging application used by more than 2 billion people worldwide. Grandparents use it to send photographs. Children use it before they understand what a server is. It requires no knowledge of how telecommunications networks function. It requires a smartphone and someone to message. Brian Hooker told this to friends. He told it to journalists covering the case. He told it to fire and rescue volunteers who came out to search for his wife. The portrait was consistent across multiple separate interactions, with multiple different people in multiple different contexts. Not a single offhand comment in a stressful moment. A recurring, consistent self-characterization offered broadly. Banfield's reporting confirmed it from multiple sources. I am being careful here about what I'm saying and what I'm not. I am not claiming this self-portrait was deliberately constructed as a legal defense for a digital evidence review. I do not know that, and I won't say it. What I am saying is narrower, the self-portrait of a man who doesn't understand technology, who finds consumer applications confusing, is directly and fundamentally contradicted by the professional record that court documents and Banfield's reporting confirm. And in a case centered on digital evidence, that gap is not small. Let me be specific about what Brian Hooker's professional credential at AT&T actually describes, because most coverage of this case has reported the fact of his background without explaining what that background means in concrete terms. An AT&T phone technician is not someone who troubleshoots your router over the phone. The designation describes someone who received formal, structured professional training from one of the largest telecommunications companies in the world in how telecommunications networks operate at a technical level from the inside. Not as a consumer who experiences the output of those systems, but as a professional who understands how the systems themselves are built and function. That training covers how signals are transmitted and received, how devices connect to and identify themselves on a network, how location data is generated when equipment communicates with infrastructure, how monitoring systems receive, process, and log data from field assets, how the company uses that data to track its equipment and audit employee conduct. This is not surface-level familiarity. It is professional-grade understanding developed through formal training with people who built these systems. The union steward dimension adds something specific. A union steward at a telecommunications company operates with detailed institutional knowledge of a company policy, including what the company monitors, how it monitors it, what the data from that monitoring is used for, and what the consequences are when a monitored employee's conduct is found to violate policy. All of that is directly relevant here. A union steward has professional reason to understand the mechanics of oversight at a technical company because that understanding is part of serving effectively in the role. Brian Hooker had both. The technical training of an AT&T certified phone technician and the institutional knowledge of someone who served as a union steward at that company. That is not the background of someone who struggles with WhatsApp. WhatsApp does not require telecommunications knowledge. The knowledge required to work as an AT&T phone technician is not knowledge that becomes inert when you leave the job. It describes professional literacy in exactly the category of systems now central to an investigation. Those two things, the self-portrait and the credential, cannot both be true in the way they were presented. Now, let me get into the specific documented conduct itself. Because I think coverage has reported it without fully examining what it actually involves at a technical level, that examination matters. A GPS tracker installed in a company vehicle is designed to operate independently of the driver. That is the entire point. It is often concealed in a location the driver doesn't know about. It transmits the vehicle's position to the company's monitoring infrastructure at regular intervals, automatically and continuously, without requiring any input from whoever is behind the wheel. The system exists because the employer does not want the driver controlling whether their location is reported. Here is the problem you have to solve if you want to hide your location. A tracker that simply stops transmitting does not help you. A tracker that goes silent creates a gap in the monitoring record, and that gap triggers an investigation immediately. You haven't hidden where you went. You've created a visible anomaly pointing investigators directly to the period you didn't want on record. To actually go somewhere without being detected, you need the monitoring system to believe the vehicle is somewhere it is not. You need the system to receive something that looks like a legitimate, unremarkable transmission, while the vehicle is actually somewhere else. That is a fundamentally different technical problem from simply cutting a power wire. Producing that result requires knowing the tracker is there. It requires understanding how the tracker transmits its data, what signal, what frequency, what protocol, and how the monitoring system processes incoming readings. It requires understanding what a legitimate transmission looks like from the monitoring end, and what an anomalous one looks like. And it requires making the former appear where the latter would otherwise be detected. That is professional-level telecommunications knowledge applied to a specific practical problem. It is not consumer knowledge. It is not something you develop by using an iPhone. It is the kind of understanding you build through formal training, with people who design these systems, and through extended professional work with them. Brian Hooker had that knowledge. He was trained to have it. He applied it. Multiple former colleagues who were there witnessed the conduct. The termination generated court documents that existed in the legal record before April 4th ever happened. Banfield reported this after 5 days in Elbow K, through access to court records and direct confirmation from former colleagues. At the time this video was produced, that reporting had not been independently cross-verified by a second-name major outlet. I want to hold that distinction, and I want you to hold it too. Confirmed sourced reporting, grounded in court documents, is not the same as cross-verified investigative journalism from two independent institutions. Both of those things can be simultaneously true. What is not disputable is that court records are legal documents. They do not exist because a journalist thought something was interesting. They exist because a formal legal process generated them. Banfield's 5 days of reporting in Elbow K produced something specific, not a general claim that investigators are looking at digital evidence, but the identification of exact categories of data under review. Jennifer Coffindaffer, former FBI agent, added a fourth through her professional assessment, reported by Newsweek. Each type works differently. Each lives somewhere different. Each has a different relationship to what Brian Hooker could or could not have influenced. Starlink handshake data. The Soulmate was equipped with a Starlink terminal, SpaceX's satellite internet system, which provides broadband connectivity in remote maritime locations, like the Bahamas. Starlink does not only provide internet. Every time the terminal connects to the satellite network, a log is generated recording the timestamp, the terminal's identifier, and the geographic coordinates of the terminal at the moment of connection. That log does not live on the vessel. It lives on Starlink's infrastructure, servers controlled by a company with no stake in this investigation, retaining the connection data independently of anything that happened on that boat. If the Soulmate's Starlink terminal was active on the night of April 4th, that connection is in Starlink's logs with a timestamp and a position. The record either confirms or contradicts the stated account of where the vessel was. There is no third option. Investigators pursuing a warrant-level investigation with a bodily harm basis have the legal authority to compel that data from Starlink through a direct legal demand. This is well within the scope of what a case of this significance can reach. Apple Watch connection logs. An Apple Watch logs its pairing history with its paired iPhone in detail, capturing when the connection was active, when it was interrupted, when it was re-established, all time-stamped. Those logs are, in effect, proximity records. When the watch and phone were near each other, the connection was live. When they were separated, the record shows a gap. In a case where a central question involves where specific people were at specific times on a specific night, a wearable device that maintains time-stamped proximity logs is forensically significant. Those logs from the devices seized on the Soulmate are in investigators' hands. What they show for April 4th is part of what the review is currently working through. AIS positioning. This one is different from everything else in the investigation, and the difference matters. AIS, the Automatic Identification System, is the maritime standard for vessel tracking, Every vessel of a certain size is required to carry AIS equipment. The system broadcasts the vessel's identity, GPS position, speed, and heading at regular intervals on a designated radio frequency. That broadcast is not a private communication directed at one receiver. It goes out continuously to shore stations operated by maritime authorities, to other vessels equipped with AIS receivers, and to satellites in low Earth orbit that capture AIS transmissions from anywhere on the ocean. The entity receiving an AIS broadcast is not the vessel. The vessel broadcasts, the world receives. The data lives with the receivers, shore stations, satellite networks, the commercial maritime tracking services that aggregate AIS data from multiple reception points globally. None of those receivers were aboard the Soulmate. None of them were within Brian Hooker's reach on April 4th or afterward. If the Soulmate was broadcasting its AIS signal that night, and an AIS transponder that is powered will broadcast continuously whether the operator wants it to or not. That signal was captured by infrastructure operating entirely independently of what was happening on that boat. The captured data places the vessel at a specific location at specific times, or it fails to do so. Not based on anything Brian Hooker told investigators. Based on what the vessel's own systems broadcast to receivers he had no ability to reach. Google search history. Coffindaffer's assessment through Newsweek was not a generality about digital evidence. She was specific. Google searches are where this case will be made. That level of professional specificity, offered in the context of an active investigation by someone who has worked digital evidence cases, is typically based on pattern recognition. She has seen what this data type produces before. A search conducted on any Google-connected device is stored on Google's servers, time-stamped, tied to the account that conducted it, and linked to the location from which it was made. Deleting the search history on a device does not delete the server-side record. That data is retained on Google's infrastructure and is recoverable through the legal process that a warrant-level investigation is fully equipped to deploy. Search history reveals things that location data cannot. What was searched for before an event? What was searched afterward? Whether the search pattern fits the profile of a person doing what they describe themselves as doing. Former investigators who have worked digital evidence cases understand that this is where motive, intent, and planning tend to become legible in the record in ways that no other data type captures as directly. I want to stay on this for a moment because I think it's the most important analytical point in the entire case. 3 of the 4 data categories, Starlink, AIS, and Google, do not live on devices that were aboard the Soulmate. They live with third parties. Starlink's server infrastructure, the global network of AIS receivers. Google's servers. These are enterprise-level systems maintained by organizations that have no connection to this investigation and no vulnerability to action by any individual on any single vessel. At AT&T, the GPS system Brian Hooker defeated was localized. The tracker was on the van. The monitoring infrastructure was the company's. The intervention point was accessible to someone with professional knowledge of how that specific system worked. Someone trained on it, who understood its architecture, who knew what the signal was and where it went. The court-documented conduct describes someone who identified a specific technical problem and applied specific professional knowledge to solve it. Starlink's server infrastructure is not a company van. Google's servers are not a monitoring system sitting in the same vehicle as the person it's tracking. The AIS receiver network is not a single point you can reach. These are distributed, globally scaled systems maintained by organizations with no vulnerability to what any individual on any single vessel did or did not do on a specific night. This is analysis. The editorial assessment of this channel, not a confirmed investigative finding, and I want to be explicit about that. If the digital record of April 4th contains something inconsistent with the stated account, The most likely location of that inconsistency is not in the device-level data Brian Hooker could have thought about. It is in the third-party infrastructure data that existed beyond the reach of his professional knowledge or anything else available to him. That is where the trail runs that cannot be walked back. Let me put this together clearly, because the full weight of Brian Hooker's AT&T background for the investigation has to be understood as a set of connected facts, not as individual data points. 3 separate documented attributed facts are on record. First, Brian Hooker consistently described himself to multiple people in multiple contexts as someone who was not comfortable with technology, someone who specifically did not know how to use WhatsApp. This was not a single comment. It was a recurring self-characterization offered broadly. Banfield's reporting confirmed it from multiple independent sources. Second, Brian Hooker was a trained AT&T phone technician and union steward, not someone who worked adjacent to telecom, someone who received formal, structured, professional training in how telecommunications infrastructure operates, and who served in an institutional role that required detailed knowledge of company monitoring practices. Third, Brian Hooker applied that professional knowledge deliberately to defeat a GPS location tracking system on a company vehicle for the explicit purpose of masking his location from his employer. Multiple former colleagues witnessed it. Court documents confirm it. That conduct predates this investigation. It was in the legal record before April 4th ever happened. The first fact contradicts the second in a way that cannot be easily reconciled. A trained AT&T phone technician and union steward does not genuinely struggle with WhatsApp. The knowledge required for one is foundational, relative to the complexity of the other. Both cannot be true as presented. The third fact does something separate. It doesn't only establish that Brian Hooker had professional knowledge of location tracking systems. It establishes that he was willing to apply that knowledge specifically to create an absent or false record of his own whereabouts. He identified a specific technical problem, thought carefully about it, and used what he knew to solve it. That is not theoretical. That is documented past conduct. Investigators reading the digital records from the soulmate are not reading them in a vacuum. They are reading them in the context of everything the public record shows about who produced those records and what that person was professionally capable of doing to shape them. The professional history is context. It changes what investigators look for and how they interpret what they find. I want to be specific about the limits of what I actually know here, because I think intellectual honesty requires it. The Digital Evidence Review has not produced public findings. An investigation pulling third-party data from satellite infrastructure, processing maritime positioning logs from global receivers, analyzing device connection records, and issuing legal demands to major technology companies does not resolve on a schedule that produces weekly updates. This takes time. Real time, weeks, often months. What the Starlink logs show, I don't know. Whether the AIS positioning places the soulmate where the stated account says it was, I don't know. What the Apple Watch connection records reflect about the proximity of the watch to the phone on the night of April 4th, I don't know. What the Google search history contains and whether it fits the profile of a person doing what they described, I don't know. Whether this investigation results in charges, I don't know. Whether the evidence will support a prosecution, I don't know. Whether there are pieces of this case not yet public that would change the picture in ways I can't anticipate from the confirmed record alone, I don't know. What I know is the confirmed record, what Banfield confirmed after 5 days in Elbow K, what CBS News confirmed about the warrant, what Coffindaffer said through Newsweek, what is in court documents. Anyone who tells you they know what the digital evidence ultimately shows, on any side of the question, is telling you something the confirmed public record does not yet support. As of the production of this video, the search warrant on the soulmate was granted and executed, confirmed through CBS News. The cited legal basis was bodily harm. Electronic devices were seized under the warrant. No charges have been filed against Brian Hooker in connection with the disappearance of Lynette Hooker. Investigators are, per Banfield's confirmed reporting, reviewing Starlink handshake data, Apple Watch connection logs, and AIS positioning. Jennifer Coffindaffer, per Newsweek, identified Google search history as the data category she believes will carry the most evidentiary weight. The digital evidence review is active and has not produced public findings. Lynette Hooker has not been found. We started with a court document. That is where we end, not with a verdict, not with a declaration about what happened on that boat on April 4th, not with a conclusion about what the digital evidence will ultimately show. With the documented record, Brian Hooker was fired from AT&T for jury-rigging the GPS tracker on his company van to mask his location. Multiple former colleagues were there. Court documents confirm it. Those documents existed in the legal system before Lynette Hooker disappeared, before the soulmate arrived in Elbow Cay, before a search warrant was written, reviewed by a judge, and served on that vessel. The record was already there. Ashley Banfield spent 5 days in Elbow Cay. She found it. She reported it. She brought that documented piece of Brian Hooker's professional history into the public record of a case where it is directly, unmistakably relevant. A case that has become, at its core, a digital evidence investigation centered on the exact category of technology he was trained in, worked with, and deliberately defeated to hide his location, as court documents confirm. That is not a conclusion. That is the documented record. The devices are in investigators' hands. The warrant has been executed. The third-party data infrastructure, Starlink, Google, and the global AIS receiver network holds layers of the record that exist beyond the reach of anyone on that vessel. What investigators find when they put all of it together is not yet known. The legal process will determine it. Not a YouTube channel, not a journalist, not anyone operating outside the formal evidentiary review that will take the time it takes and produce the findings it produces. Lynette Hooker's family has been waiting since April 4th. They deserve answers. The documented record, everything confirmed, everything sourced, everything attributed, belongs in front of every person who has decided this case matters enough to follow it. We will follow it wherever it goes. If you've been with this case since the beginning, if you knew Lynette Hooker's name and the soulmate and what a bodily harm warrant means before you click this video, thank you. People who sustain attention when the mainstream coverage moves on are the reason this kind of work is possible. If you're new here, this channel covers true crime investigations with documentary discipline. Every factual claim is sourced. Every inference is labeled as inference. We don't convict people in YouTube comment sections. We follow the documented record and report where it leads and where it doesn't. Subscribe if that is what you are looking for. Every confirmed development on the Lynette Hooker investigation will be covered here the moment it becomes reportable, sourced, attributed, and clearly distinguished from analysis. That is the standard. The comment question: of the 4 confirmed data categories in this investigation, specifically Starlink handshake logs, Apple Watch connection records, AIS positioning data, and Google search history, which do you believe is most likely to determine where this investigation goes next? And why? Drop it below. I want to understand where the people who have followed this case to the end are landing. This investigation was presented based entirely on confirmed reporting by Ashley Banfield through Drop Dead Serious, including 5 days of on-the-ground reporting in Elbow Cay, CBS News confirmation of the search warrant and its cited legal basis of bodily harm, Jennifer Coffindaffer's professional assessment as reported through Newsweek, and court documents as referenced and confirmed in Banfield's reporting. Brian Hooker has not been charged with any crime in connection with the disappearance of Lynette Hooker. He is presumed innocent under the law. That presumption is not a formality. It applies to every claim in this video and to every stage of the ongoing investigation. The reporting on Brian Hooker's termination from AT&T, including the GPS jury rigging, the former colleagues, and the court documents, has been confirmed through Ashley Banfield's reporting. At the time of production, it had not been independently cross-verified by a second-name major outlet. That distinction is maintained throughout this video. The conduct described is confirmed past conduct at a prior employer. It is not an allegation of criminal wrongdoing in the current investigation into Lynette Hooker's disappearance. All analytical framing in this video, including the assessment of what Brian Hooker's AT&T background means for how the current digital evidence review should be understood, is the editorial analysis of this channel. It is not a confirmed investigative finding. It is not a statement of guilt. It is not a legal conclusion. It is labeled analysis, based on confirmed facts placed in the context of a confirmed investigation. This content is for informational and educational purposes only. It is not legal advice. It is not a verdict. The legal process will determine what the evidence shows. This channel will report that process as it develops, with the same sourcing standards applied throughout this video. Lynette Hooker has been missing since April 4th, 2025. Her family deserves answers. The documented record belongs in front of everyone who has decided this case is worth following.